Medina Osório. Now, good morning, everyone. And now it's up to me to talk about the objective, accountability, or responsibility in the anti-corruption corporate law. And I will bring certain reflections about this topic to try and contribute with this debate. Remember, I would like to remind you that this seminar is being broadcast online, streamed live in Portuguese and in English, and it's being followed live. Therefore, we're here dealing with the new paradigms of the corporate anti-corruption law of 2013. To deal with this topic, the objective responsibility of a legal entity of this law, I'd like to establish some premises. The first premise has to do with the discussion on in which moment this strict liability was introduced in the Brazilian legal system of the corporate entity, a legal entity, and the first discussion that should be established. And what kind of strict liability we're talking about? This corporate strict liability, or the legal entity strict liability, is different from the strict liability that is provided for in the 88 Constitution, which is the one of the state, as a compensation for damages, the civil liability of the state, which is a type of objective or strict liability of the legal entity, which is the one of the state, that is provided for in the 88 Constitution. So we have to differentiate this liability, the strict liability of the legal entity, dealing with it as an liability of sanctioning administrative aspect. So it is important to establish this liability as in the law of 2013 as the liability established by the Sanctioning Administrative Law against corruption or corruption acts committed by third parties, because the legal entity doesn't act on its own. It always manifests its willingness by third parties. So it's not the same as the civil liability or the state liability. This was provided for in the Constitution of '88. There is a difference between the state liability that was in the Constitution of '88 and the liability of the legal entity in the Sanctioning Administrative Law again for acts of corruption by third parties. And on the other hand, these responsibilities that is within the corporate liability law due to acts of administrative acts. It is a very specific liability. Sanctioning administrative law and corruption acts. It doesn't mean that there are other types of legal entities in the administrative law, such as the accountability on the labor law. Before this law was passed. There was the liability in the labor law and other types of liability, but not for due to corruption acts in the sanctioning administrative law. Not in the strict liabilities in this sphere. Therefore, there is a consensus, especially due to legislative works and the recognition within the Office of the Controller General, in the sense that this modality of responsibility due to actions or corruption acts was an innovation of the law that was passed in 2013. Before this law going into effect, this was not a type of strict liability that was in effect. And especially within the procurement law here in Brazil, it was subjective. And the law 2846 could not be applied, could not be enforced retroactively. So the Office of the Controller General had a specific liability before the law 2846 and a way of liability that was subjective. What was the subjective liability that was enforced not only by the Office of the Controller General, but the state agencies as well? It was the assessment of willingness or fault or guilt according to the natural persons. The punishment of the companies had to do with the assessment of the willingness of the act or the fault of the natural persons. And that was extremely necessary for the accountability of the companies or for establishing the liability. And therefore, we had the principle of fault-based liability. And it was the accountability of the corporate entities at the light of this other previous law of the malfeasance law, or in this case, a misconduct law, because the companies, they were under the other law, they weren't under the other law 8429 as the beneficiaries of the act of misconduct. And a lot of them were in the defendants, and a lot of them in these lawsuits, even though it was not correctly developed, the the thesis of accountabilities of the legal persons. Let's see the lack of individualization of the natural persons. When people, workers of the legal entity were practicing and bad or misconduct. And these people were not part of the board of directors of this corporation. Some more water, please. These workers and within the federal institution to represent the legal entity for commission of acts in the procurement process or in a tender process. And let's say that is the hypothesis. These workers were conducting irregularities or misconduct, and they were in, as they were defendant in an action, a lawsuit of mispractice or misconduct. But these people were not doing this because they had the responsibility of the social contract. The directors had the responsibility of, and they were the people establishing the willingness of the legal entity. And let's say that the person filing the suit doesn't produce evidence in the sense that the workers were not connected whatsoever with the directors of the legal entity in order to commit this situation. And what is this situation like in an action of misconduct? And with the lack of the subjective link or bond, and describing the principle of culpability, and due to the lack of the individualization of the conduct of the natural person in the legal corporation, legal entity. So the principle of the fault-based liability presumes the description of the legal person and the description of a conduct that will materialize the willingness of the legal entity, or the description of the conduct of someone that is following the orders of the person that materialized the willingness, the will of the legal entity. So there might be a plea bargain in the sense of elements to corroborate this. There should be this link here. At the light of the law 8,429 of or the procurement law as well. Under the law before the Anti-Corruption Act's law. And right after that, in all the normative system, what is the normative system in terms of the system of fault-based liability, and how does it work? And now, there are many lawsuits of misconduct don't have the elements due to the lack of description of the subjective element, conduct, elements of the conduct, and for basically saying that this didn't happen. What happened with this? The change in the law of the action against misconduct in public office. It made it not applicable in the third article when it says that when the fact is an act of corporate misconduct, or can be framed in the law of corruption acts, this law is enabled or enforced to the legal entity, and the law of public misconduct is not applicable or not enforced in the legal entity. Well, if this is true, and the law is self-enforceable in the immediate aspect, what happens here? In the process that are ongoing, in the actions against misconduct in public office that are ongoing, we must say that the process should be dismissed in case this same facts that are mentioned against this legal entity are infraction that is typified or that are defined in the Anti-Corruption Act corporate law. Because if those facts are based in the law, this law, the action against misconduct in public office should be dismissed because it should send the file to the Office of the Controller's Office and not the other way around. And in the situation of the legal entity, the presuppositions or the presumption are totally different. In the action against misconduct, the principle of liability is subjective, right? It's true if the facts are before the anti-corruption corporate law. This law is not enforced, it's not applicable. This rule is not applicable. This rule is applicable if the facts happen after the passing of the law. Only what's applicable is the tender law or the procurement process law or action against misconduct in public office. But let's look at the corporate anti-corruption corporate law, because we're looking at the fault-based liability principle, and this principle has been misinterpreted considering legal entities or even natural persons. And it is connected to the arbitrary power and the description of the conduct that is forbidden, the causal link, and also the guilt, and how this should be described in the initial part of the lawsuit, as this should be described. Let's look at the objective or the strict liability. There are some reports within the Office of the Controller, the General Controller, saying that the fault-based liability is that it presumes the analysis of intent and fault of the physical or the natural persons. That was a decision that was passed within the administration of the Minister Wagner Rosário. I have the report here. But it's a report that has the specific understanding. It is the case, the decision on the case Promon. 00190 0041 65/2015, and the interested party is Promon Engenharia Limitada. So the adequate interpretation of the expression fault-based liability, it means to attribute that to the illegal entities and represented by its members. That's the report. In a consortium, it is necessary to show the individualized liability of each one of the companies that are in consortium, and it's not enough the evidence that's to say that one of the companies defrauded the procurement process. But in relation to intent and of the agents, it seems that strict liability is not exactly this. It's not what I mention in my work. What I mention is another type of theoretical position in the Sanctioning Administrative Law. The strict liability of the legal entity walks hand in hand for an organization in failure. So if there is an act, if there is a corrupt act that is practiced, or fraud, an objective fraud, that is perpetrated or materialized in this situation, what has to be investigated in terms of the accountability or liability of the legal entity is the possibility of avoiding that act. Naturally, if there are excluding factors, considering the non-existence of the fact, if there are excluding situations due to the non-existence of the fact, or the causal link, the lack of the causal link with the person, that is the representative of the corporation, it means that this excluding factor is going to affect the legal entity or the lack of material aspect of the fact. So there is some excludent situations that affect the legal entity. That affects the liability of the legal entity. There is no material aspect. There is a lack of linking bond between the person and the fact that impacts the liability of the legal entity. there are some exclusionary conducts that impact, but as the fraud existed and it was proved, if the fraud was proved, there is a concrete problem for the legal entity to face. If there is an affirmation of the fraud, if a confirmation of the fraud, there are some exclusionary facts that will not help the legal entity. I'd like to say hi to the Justice Navarro, who's just arriving here, that there will be exclusionary causes that will not help the legal entity. In this sense, fraud, the legal entity will have to prove that whether we have to work with the concept of avoidability within the organization. Because in the fault-based liability, we have to consider that each corporate entity, so if we consider the multinationals,
and if we do a parallel to this company, this private company, we need to trace also for the public sector. We cannot, be more strict with the private sector than the public sector. And that's what we need to take into consideration. If in the public sector, an integral sector, for instance, the judiciary, if we consider the judiciary, for instance, or the executive power, or any other institution, in other words, one that's integral, she will admit, will she admit any statistics of corruption? An honest institution in Brazil, will she tolerate any kind of statistics of a corruption index? If such institution with a reasonable amount of integrity accepts any kind of corruption index, even with having compliance mechanisms and controlling mechanisms, why won't we adopt the same kind of parameters as the private sector? That's the question. That's my point. For instance, the Brazilian judiciary or the armed forces, for instance, other institutions and the executive power. Let's say if we look at an evolution of the executive power, it will have problems of corruption. Any institution will have a corruption. Listen, even in Norway, you have corruption. Even in Finland, everywhere you do have corruption. So any institution will have some kind of index of corruption. And so if she does have that index of corruption, obviously, we have to admit that any big corporation may have this corruption at some point. Will you punish this corporation if there is fraud necessarily? No, you cannot just necessarily do it in an objective way. You have to verify always if the company has the mechanisms of compliance. And if it does, as far as I know, these mechanisms, and this is what I'm writing in my work, that's why I say these mechanisms of compliance effectively, they don't just exist to bring down sanctions, to make them easier or to exclude the causing factor. If they do have compliance factor, they have to exclude what's causing among the conduct of the company and its culpability by the effective organization. And this is where we come with the theory and thesis of defect or organization when it comes to this is also why we bring in our work and culpability of the legal entity and defective law is when the legal entity adopt measures, and then this, I could talk a little bit longer about this. I'm going over my time, I'm sorry, but I want to say that effective compliance, who has a great guide of compliance is CADE. We need to combat the CADE. We have to combat the facade, and we have to have a structure that's more certified, more and more certification. And the corruption law, when it came, I went to the yellow pages of Veja. It was 2014. As a jurist, I said, I wasn't minister yet, I was just this. We can have an industry of compliance. So we have several offices that's going to be working on it. And that's when it came up. The problem today is first to format compliance based on certification, international certification. And for instance, listen, we have Proética and CGU. There's no point in having certifications that have no credibility. We need to search and look for international certification. We need to try to have certifications at CGU and the compliance based on certifications. We need to have criteria, ethical sustainability for compliance. And we need to look to have the concept of officer compliance that's independent, an independent one, so that this council of officer compliance is more and more, works more and more. And we've had the governors and directors, governance, such as Navarro, Spinelli, and other technicians that were excellent on the market, and the market began to use these technicians of this magnitude in order to add credibility for the companies, the private companies and public companies, because we cannot look at the private companies and not having the credibility of the governance manager and their compliance officer. And why is that? Because we live in a time where my dear friend Diogo de Figueiredo Moreira Neto used to say, public space is not from the state. Public space not from the state. That's where the private companies need to cooperate with the public sector that's not state-owned, and need to cooperate also with the private sector, the state-owned part. Then we're going to be able to reduce this punitive spectrum of the public ministry. It needs to occupy all the space, with all this will of giving fines and the checking, excessive checking. We need to move towards auto-regulation, auto-monitoring, and more judiciary safety, and where all the companies together with the judicial power go to this solution of conflict, like in the United States, outside of the judiciary, because no one anymore can take trying to survive within this judiciary. The judiciary power is very unpredictable, it's very slow, it's very expensive. I remember studying in college Dennis Lloyd, the idea of law, and he used to say, the law is the same for everyone, just like Del Hits is anybody can start. Anybody can get in the courts, but how long does it take for you to resolve a contentions? And just like Gustavo Belka, I studied in the 90s. It's the right, and it should be a malleable right in the hands of the public authority and the judiciary power and the public ministry, and we don't know this what kind of right we have. Tomorrow it's a new one. So it's much better to look for these regulating agencies that are composed by technicians, which is CGU, like CAD, and there are agencies that are specialized in solving conflicts outside of judiciary. In other words, an auto-regulation, auto-composition. So this law of anti-corruption, this anti-corruption law that's in the corporation, it's to help effective compliance and allow that are some agencies here that are those in the executive power. We can look at the paradox that Minister Marcos Carvalho mentioned here. Authorities trying to have the monopoly to combat corruption in Brazil, trying to promote a regulation, a retro-regulation, much more distant from reality, over illicit things, when the reality, the way is prevention, and allow auto self-regulation to take its course. So I see that these concepts, they're fluid, should permeate this auto and self-regulation, and the concept of self-responsibility that's objective that we're talking about here are filled, let's say, so to speak, from a perspective that can be understood by a sustainable corporation, and the company can understand that a fault or a problem in her corporation can generate responsibility, and through an ethical sustainability, she can prevent that. And the responsibility, the subjective responsibility, which is the concepts before the law, can be better understood. But this concept of objective responsibility is not a concept of integral risk. It is an idea. It's a very important idea and topic, because sometimes the concept of objective responsibility is mixed with one of integral responsibility, and responsibility for entire integral risk. It's like the company was responsible for everything that's happening. And if that was the case, so any fraud that's happening in the corporation, she would be punished. That's not how it works. There are many excluded factors that should be defended. The company is not punished automatically because fraud somehow happened. The company has, the entity has the right to fight. The fact may not have happened. It may have not have anything to do with some unnatural person, and the fact the company may be very well organized, very well structured, and has a right to present that. And I repeat, any institution that is very well structured in her compliance and her mechanisms of integrity and cooperate with institutions that are fiscalizing everything, she might have some index of corruption in her organization. So the occurrence of frauds in any organization, no matter how wonderful she is, can happen. What she needs to come to fruition is to take these and give it to the public entities. It's not just because one fraud happened inside the organization, she'll immediately be punished. That's not how it works. So these reflections that I wanted to bring here, and thank one more time President Beto Simonetti for the help, support of the sanctioning and the seminar. President Beto Simonetti has done a very important managing of this and of his overseeing OAB, and especially thanking him and all the speakers, especially starting with Minister de Carvalho and all of us who are here in the seminar. Thank you very much to everyone who has been listening to us. Thank you.